Thank you for your attention. I hope you have enjoyed this basic overview of the requirements of subparts B, C, and D of 45 CFR Part 46. To conclude our talk, there are several points that I would like to summarize regarding vulnerable populations. First, if an IRB regularly reviews research involving vulnerable subjects, it should include one or more members who are knowledgeable about and experienced in working with these subjects. Be sure that you understand the applicability of subparts B, C, and D may change during the course of a project. For example, if a subject who is currently involved in research that was not approved under subpart C becomes a prisoner after enrolling in the research, the IRB must re-review the research in accordance with the requirements of subpart C. If the investigator wishes to have the subject who is now a prisoner continue to participate in the research. The same applies for subpart B for women who enroll in research and subsequently become pregnant. Remember that the IRB must determine the category of permissible research described in subparts B, C, and/or D, and may only approve research which satisfies the conditions of all applicable sections of the subparts. Remember that there are limits on the applicability of the exempt categories of research for research involving prisoners or children. When conducting research involving children, make sure that you understand the differences between informed consent, parental permission, and child assent, and use each when appropriate. Understand the criteria that must be met when waiving the requirements for obtaining informed consent, parental permission, or child assent. If you have questions, please feel free to refer to the OHRP website, send us an email, or call us. Thank you very much for your time and attention. Our session is over, but we have a little more time if you want to come up here with any questions.
Hi, I'm a new IRB manager, and so I'm going to jump right in with some questions about Subpart C and prisoner research. In your comments about prisoner research in Subpart C, you mentioned requirements related to certification. Can you tell me when an institution needs to provide that certification and what it means?
Before an institution conducts research involving prisoners that is conducted or supported by HHS, the institution must certify to OHRP in writing that an IRB has reviewed the research under Subpart C and made the 7 findings required at 45 CFR 46.305A. Note that the first of these 7 required findings is that the proposed research fits into one of the permitted categories of research involving prisoners found at 46.306A2. The IRB may also determine that the research qualifies for application of the secretarial waiver, allowing prisoners to participate in certain epidemiological research, which was approved by the HHS Secretary in June 2003 under 46.101I of the regulations. This epidemiological waiver acts as a very narrow 5th category of permissible research involving prisoners. Once OHRP receives the certification, we review it and make a final determination as to whether the proposed research involves one of the categories of research permissible under the regulations or the epidemiological waiver, and if so, which one? Note that OHRP's category determination may not be the same as the IRB's. Research activities involving prisoners may not begin until we have issued an authorization letter and indicated that we agree that the research represents one of the permissible categories of prisoner research.
You also mentioned a requirement for secretarial consultation for prisoner research. Can you tell me about this secretarial consultation?
For all research that falls into the category of research described at 45 CFR 46.306A23 and a subset of research that falls into the category described at 45 CFR 46.306A24, the regulations require that the Secretary consult with appropriate experts, including experts in penology, medicine, and ethics, before the research may proceed. OHRP carries out these consultations on behalf of the Secretary. We call this process a secretarial consultation. If a secretarial consultation is needed, OHRP will inform the institution that submitted the certification of the need for this consultation. The research may not proceed until the consultation process is completed and OHRP has announced in the Federal Register of the Secretary's intent to approve the research. An example of a research activity involving prisoners that would require a secretarial consultation might be a trial of a hepatitis vaccine that involves assigning a prisoner to a control group that may not benefit from the research.
We're getting a grant from a local county correctional facility to do a research study to find out whether certain innovative mental health interventions have an impact on recidivism. Some prisoners will serve as healthy controls in the study, and they may not benefit from the research. Now, if we check the box on our federal-wide assurance to apply the regulations at 45 CFR Part 46, to including all of the subparts, to research regardless of the source of support, do we need to provide for secretarial consultation or submitting a certification for that kind of prisoner research when there is no HHS support?
The short answer is no. For research involving prisoners that is not conducted or supported by HHS, secretarial consultation and submission of a certification to OHRP are not required, even if your institution has checked the box.
Okay, but if we check the box and do not get HHS support, we still have to comply with the other provisions of Subpart C, right?
Yes, that is correct.
Now, if I understood you correctly, research involving prisoners is not eligible for exemption under 46101B, regardless of the kind of activity. But is expedited review allowed for prisoner research so long as it's minimal risk?
When research involving prisoners meets the criteria for expedited review under 45 CFR 46.110, such an expedited review procedure is permissible. However, because of the vulnerability of prisoners, OHRP recommends that all research involving prisoners be reviewed by the convened IRB. If the research is reviewed under the expedited review procedure, OHRP recommends that the IRB members reviewing the research include a prisoner or prisoner representative.
I have two last questions. First, does Subpart C apply to research involving people on parole or people who are confined to a mental institution?
As I noted earlier in our presentation, the regulations define prisoner as any individual involuntarily confined or detained in a penal institution. The term is intended to encompass individuals sentenced to such an institution under a criminal or civil statute, individuals detained in other facilities by virtue of statutes or commitment procedures which provide alternatives to criminal prosecution or incarceration in a penal institution, and individuals detained pending arraignment, trial, or sentencing. Subpart C would not apply to research involving parolees who are living in the community and sentenced to community supervised monitoring, because such parolees would not be considered detained and are therefore not prisoners for purposes of Subpart C. Similarly, an individual receiving non-residential court-ordered substance abuse treatment who is residing in the community is not considered a prisoner, so Subpart C would not apply. On the other hand, Subpart C would apply to research involving parolees who are detained in a treatment center as a condition of parole. Subpart C would only apply to subjects in a mental institution if they have been involuntarily confined by a court order to a non-penal facility as an alternative to incarceration. However, subjects who are civilly committed to mental institutions are not considered prisoners.
My last question involves the use of electronic monitoring devices. If an individual is wearing an electronic monitoring device, but is living outside of the prison, say in their apartment, does Subpart C apply to research involving that kind of individual?
This can be a hard call. In general, if a monitoring device is intended to only monitor the whereabouts of an individual, it does not make them a prisoner. The amount of restriction imposed should be taken into consideration. If the device is used to detain the individual, they could be considered a prisoner. The IRB can determine this on a case-by-case basis, depending on the specifics of the case, and is encouraged to consult with the OHRP in making its determination. Did you have a question?
Yes, I did. I have a question that involves Subpart D, the additional protections for research involving children. I'm thinking of doing a study involving children, and we'll be asking for information about history of physical and sexual abuse. Now, I understand the importance of seeking child assent and parental permission. Now, my research would probably fall under Category 405, which would normally only require permission from one parent. However, I'm a little concerned that seeking parental permission in this case would actually put the children at additional risk, because especially if one of the parents is the source of the abuse. Now, is there any way that is there any alternative to this parental permission requirement? I really want to protect these kids.
Before I answer your question, let me take this opportunity to remind you of the categories of research in which children can be involved as subjects. There is Category 46.404, research not involving greater than minimal risk. Category 46.405, research involving greater than minimal risk, but presenting the prospect of direct benefit to the individual subjects. Category 46.406, research involving greater than minimal risk and no prospect of direct benefit to individual subjects, but likely to yield generalizable knowledge about the subject's disorder or condition. And Category 46.407, research not otherwise approvable by the IRB, which presents an opportunity to understand, prevent, or alleviate a serious problem affecting the health or welfare of children. This last category requires secretarial consultation with a panel of experts. Now, to answer your question, an IRB may either waive parental permission under 45 CFR 46.116 C or D, or an IRB can determine that parental and/or guardian permission is not a reasonable requirement to protect the children, provided that an appropriate mechanism for protecting the children is substituted and the waiver is not inconsistent with federal, state, or local law. This provision is described at 45 CFR 46.408C and is an alternative to the conditions of 45 CFR 46.116 C or D.
So it sounds like you're saying that it might be okay to have an advocate present during the research interactions in order to ensure adequate protection of children in research as an alternative to requiring parental permission. So I could go forward with my research without actually getting permission of the parents. Is that correct?
Well, an IRB would need to make that determination, but it could be a reasonable approach depending on the specifics of the research. The choice of the appropriate mechanism would depend upon the nature and the purpose of the activities described in the protocol. the risk and the anticipated benefit to the research subjects, and their age, maturity, status, and condition.
Can either of you think of any other situation where it might be appropriate to have advocates involved in order to protect children in research?
Advocates are required under 46.409A when children who are wards of the state or any other agency, institution, or entity are to be subjects in research approved under Category 46.406 or 46.407. That is, when the research is approved by the IRB under one of these categories, the IRB must require the appointment of an advocate for each child subject who is a ward, in addition to any other individual that is acting on behalf of the child as a guardian or in loco parentis. In these circumstances, one individual may serve as an advocate for more than one child. The advocate must be an individual who has the background and experience to act in and agrees to act in the best interests of the child for the duration of the child's participation in the research. The advocate may not be associated in any way except in the role as advocate or member of the IRB with the research, the investigator or investigators, or the guardian organization. An IRB could also choose to appoint advocates for child subjects under other circumstances.
Is it always necessary to obtain child assent?
No. In particular, note the following. The IRB determines whether the children expected to be enrolled in a research study are capable of assenting, and if so, whether adequate provisions are made for soliciting their assent. If the IRB determines that the children are not capable of assent, assent is not required. Assent is not required if the IRB determines that the intervention or procedure involved in the research holds out a prospect of a direct benefit that is important to the health or well-being of the children and is available only in the context of the research. This is described at 45 CFR 46.408A. The IRB may waive the requirement for obtaining assent under circumstances in which consent may be waived under 45 CFR 46.116C or D. Also, for children whose age and maturity level limits their ability to fully comprehend the nature of the research activity, but who are still capable of being consulted about participation in research, it may be appropriate to focus on conveying an accurate picture of what the actual experience of participation in research is likely to be. For example, what the experience will be, how long it will take, whether it might involve any pain or discomfort. Finally, note that once a child reaches the legal age of consent, an investigator needs to obtain informed consent for any ongoing human subject's research activities involving that subject, unless the requirement to obtain the subject's informed consent can be appropriately waived by the IRB under 45 CFR 46.116C or D.
What's the best way to document assent?
The regulations at 45 CFR 46.408 indicate that an IRB must determine whether and how assent must be documented. It really depends on the type of research and the capacity of the children. It would be best to discuss the details with your IRB. Note that in some cases, an IRB may determine that assent is required, but documentation of assent is not necessary.
I have another question. Is it ever possible to waive assent for a child when it's in their best interest to participate in the research? I'm thinking of a rare situation where the the research may be the only chance for a cure for the child, but the child may not really be capable of understanding that. And if they didn't assent, they might die relatively quickly. So it seems like a disturbing catch-22 in the situation that doesn't really protect the child. So in this case, it seems like you couldn't waive assent because it wouldn't meet the criteria for waiver under 46.116.
Great question. Let's take a look at 46.408A, which states, in part, if the IRB determines that the capability of some or all of the children is so limited that they cannot reasonably be consulted, or that the intervention or procedure involved in the research holds out a prospect of direct benefit that is important to the health or well-being of the children and is available only in the context of the research, the assent of the children is not a necessary condition for proceeding with the research. So the IRB could determine that the assent of the children is not necessary for the situation that you just described. The IRB would not need to find the criteria for the waiver described at 46.116C or D for such a situation.
This is really helpful. I want to make sure that I do things right. I'm thinking about another study in which I am going to get parental permission. Is it better to approach the child first or the parent?
The regulations do not speak to the timing of these interactions. There may be practical considerations that might influence the order. For example, the IRB might consider whether either the parent or child is likely to be embarrassed or offended if the other is asked first.
While we're on the subject of children, I understand that the regulations describe a category of research under 407 as research not otherwise approvable by the IRB, which presents an opportunity to understand, prevent, or alleviate a serious problem affecting the health or welfare of children. I understand this category is used for research that an IRB has found does not meet the requirements of 46.404, 405, or 406. Can you tell us more about the 46.407 process for secretarial consultation with a panel of experts, and where we get more information about this process?
Sure. The details of the 46.407 process are outlined on the OHRP website, but I'll let you know that it is a fairly lengthy process that includes requests for public comment and a review by a panel of experts. In addition, OHRP works jointly with the FDA on this process when the research is also regulated by the FDA. An example of such research might include having healthy children participate in a control arm of a study where the research involves greater than minimal risk to these children and there is no prospect of direct benefit to them.
Hi, I'm an IRB chairperson, and I have a question about some research that might fall under Subpart B. If an investigator is recruiting women of childbearing ages, should they always screen them with a pregnancy test?
Subpart B does not require that women of childbearing age be routinely screened to determine if they are pregnant before enrolling them in research. If the research at issue is risky to pregnant women or a fetus, it may be appropriate to screen them with a pregnancy test. For example, if the subjects will be taking medications that may cause harm to a fetus, a pregnancy test may be prudent to ensure that risks to subjects are minimized and reasonable in relation to anticipated benefits, if any, to the subjects and the importance of knowledge expected to result.
My question involves a broader issue of potential vulnerability, not one specifically related to any of the subparts, but what about non-English speaking subjects? Are they considered vulnerable under the regulations, and what other considerations are necessary?
OHRP would not consider non-English speaking subjects a priori to be vulnerable as a class. For more information on this, you may want to take a look at our guidance document on our website. obtaining and documenting informed consent of subjects who do not speak English. You may also wish to look at the FDA guidance on informed consent for FDA-regulated research.
And what about other potentially vulnerable subjects, such as those that are mentally incapacitated, even if it's just temporary, or perhaps somebody that has a chronic illness, such as asthma or HIV, or maybe somebody who's handicapped, or even if they're just, perhaps economically disadvantaged or educationally disadvantaged. We in our institution even include subjects who are students and employees as vulnerable, when we review it at our IRB. Do you have any thoughts about that?
When regularly reviewing research involving a vulnerable category of subjects, the regulations state that an institution needs to give consideration to including one or more IRB members who are knowledgeable in these areas and experienced in working with these subjects. As you know, the HHS regulations at 45 CFR 46111A3 require that in order to approve research, the IRB needs to determine that the selection of subjects is equitable. In making this assessment, the IRB should take into account the purposes of the research and the setting in which the research will be conducted, and should be particularly cognizant of the special problems of research involving vulnerable populations. In addition, under 45 CFR 46.111B, in order to approve research, the IRB must determine that when some or all of the subjects are likely to be vulnerable to coercion or undue influence, such as children, prisoners, pregnant women, mentally disabled persons, or economically or educationally disadvantaged persons, additional safeguards have to be included in the study to protect the rights and welfare of these subjects.
I have one last question. Is it okay to do emergency research on vulnerable populations under the secretarial waiver of informed consent for emergency research when there is a potential for benefit to subjects?
The secretarial waiver under HHS regulations at 45 CFR 46.101I of the informed consent requirements for certain emergency research does not apply to emergency research involving pregnant women, fetuses, or prisoners. However, this secretarial waiver does apply to certain emergency research involving children.
Well, if that's all, I think we better wrap it up. Thanks again for participating in this session.
Thank you.
Thank you.
Thank you.